All right, I think we'll get started here. Since Joyce is going to give sort of a historical perspective, I won't spend too much time introducing her. Suffice it to say that in a couple years now, it will be 4 decades that Joyce has been inspiring and a mentor to many people in the animal law field, including myself. And a few years ago, it was an honor for me to spend a couple years working right across the hallway from Joyce at the Animal Legal Defense Fund. And she has a host of great insights, and that is why she is known as the mother of animal law. So I will, without further ado, let her fill you in on that whole history. Thank you. Thank you, Joyce.
Thank you,
and
Chris.
thank you to the ALDF for organizing this wonderful event.
Yeah. Yeah, thank you to ALDF for the good food. Am I being heard? Let's see if how's that? Yeah? Okay. If you hear me, great. Okay. My name's Joyce Tischler. Thank you for coming today. I want to share with you some stories, because my mind works in stories, not in numbers, not in data, but in stories. And I'm going to talk about some of the early cases that we were involved in. And let's save questions for the last. We'll leave 15 minutes at the end. Yeah. People can ask what they'd wish then. But for right now, I'd like to tell you some of these stories. For those of you who are in the animal law class, a couple of these cases will seem familiar, and maybe this will fill in some of the details of what was behind the case. And for those of you who are planning to practice animal law, my goal is to get you to think, if you don't already, strategically about what we can do to protect animals and establish their legal rights. In the early days, we were writing on a blank slate, and we made some good choices. We made some serious mistakes. We stumbled, and each time, with each case, we learned what we were doing. We learned how to do our work. I'm going to start, and if people have problems with graphic photos, I'll try to tell you ahead of time. Graphic photo coming up. The very first animal rights lawyer was Professor Henry Mark Holzer. He taught at Brooklyn Law School in New York City, and he focused on constitutional, administrative, and appellate law. And he gave a donation to a group called Friends of Animals. It wasn't a very big donation, he said, but it was big enough that the head of it, Alice Harrington, invited him to dinner. And over dinner, she was talking about the Federal Humane Methods of Livestock Slaughter Act. And that act specifies that in order for slaughter to be considered humane, the livestock must be rendered insensible to pain before they are shackled, hoisted, and then bled to death. In other words, the workers have to, before they can bleed the animal to death and cut him or her up, they have to render the animal unconscious and insensible to pain. However, the act also defines ritual slaughter, which we know now as kosher or halal slaughter, as inherently humane. In addition to that, the act specifically exempts ritual slaughter. Okay? So this is a touchy subject. I understand that. I'm a Jew, so I get a free pass on this one. And the question is kosher slaughter inherently humane? And the answer that I have is that as traditionally carried out, yes, it was. The animal would be held still on the ground, and the carotid artery would be severed, which would produce relatively quick unconsciousness. Slaughter is slaughter. It is not euthanasia, and that's about the best you can hope for. However, under modern American health laws, animals can't be held on the ground. That was precluded. So slaughterhouses developed the shackle and hoist method, by which the animal would be chained by a rear leg, hoisted into the air off the ground, and then the carotid artery was supposed to be slit. The problem is, oftentimes the animal was flailing about, hips would dislocate, people would get hit by the animal who's struggling, and sometimes the artery would be missed. And when I watched kosher slaughter in a slaughterhouse in Los Angeles, when that happened, the animal was just wheeled over to the side so that he could just die whenever that happened. So why did Congress make a compromise on this point of what's humane and claiming that kosher slaughter was humane? And it's pretty simple when you think about the timing of this law. It was the late 1950s, a little over a decade after World War II had ended, after the Holocaust. Jewish leaders in the United States reminded Congress that one of the first things the Nazis did was to ban kosher slaughter. So opposing that exemption would have meant that the bill would not have passed. HSUS, which was a very young organization at that point, made the compromise and achieved the passage of the first federal legislation that set humane standards of slaughter. Henry Mark Holzer, being a constitutional lawyer, said, I think it's unconstitutional and I want to fight it. So he filed a lawsuit. He couldn't find plaintiffs, so he listed himself because he's Jewish and an atheist, so he figured I'll pass muster for standing. But out of the woodwork came a woman named Helen Jones. So if in your class you're reading Jones versus Butts, that's Jones. Helen Jones was one of the founders of the Humane Society of the US. She was royally peeved when they made this compromise in the Humane Methods of Livestock Slaughter Act. She later left HSUS and went on to found a group today called the International Society for Animal Rights. So he was joined by Helen Jones, and this lawsuit, Jones versus Butts, alleged that the Act's provisions relating to ritual slaughter were unconstitutional as written and as applied because they provide separate treatment and special protection to the dietary preferences of a particular religious group. First Amendment, free exercise, and establishment clauses. Well, the district court did not agree. They held that the Humane Slaughter Act did not violate the Establishment Clause, and the Court of Appeals also agreed, and they failed. Okay? So the lawsuit went nowhere. They were challenging the chain and shackle practice, which now today there are more modern methods. But it was clearly an inhumane method of slaughter. So why did they lose? And that's a rhetorical question. The answer is human beings sit on the courts, and they were not going to overturn the will of Congress on such a politically sensitive issue. The legal reasoning of this decision, I find it to be strained and shoddy. But what Holzer experienced in this first case is something that has plagued animal lawyers ever since. And that is the simple fact that human interests override animal protection throughout our legal system. But to my knowledge, this was the very first true animal rights protection lawsuit, and it grew out of a tension between those who wanted to protect or wanted to provide meaningful protections to farmed animals going through slaughter and those who sought to protect an age-old religious practice. This was also Henry Mark Holzer's entry into the world of animal rights, and he didn't merely represent his clients and then move on. He joined the cause. He consciously extended the concept of public interest law to the plight of animals. He's retired now, but he still is actively involved in ISAR. So that gives you the very start. About 5 years later, you can all say, "Ah, how cute she was." Yeah. On the other end of the country, I was in private practice with a small firm in California, and I was doing reasonably nice work, redevelopment, real estate, wills, just generally good, civil practice. And the fact is I was miserable. I would get up in the morning and say, oh shit, I have to go to work today. And I wondered if that's how it was going to be for the next 30 years of my life. And the reality is that I didn't care about my clients. And they deserved someone who cared about them. And what I really cared about was animals. But there was no place to put that at that time. So after a while, I met another attorney, just one other attorney, Larry Kesnick. And Larry was working for a large firm in San Francisco. He was a partner with the firm. And so we thought, well, there's two of us. Maybe there's more. And this was 1979, so we put an ad in our local legal newspaper, and 6 people showed up, and that was our posse. And for many months after that, and a couple of years, we would meet once a month at the Fund for Animals office in San Francisco, and we would teach ourselves about the California laws and the federal laws related to animals and the problems faced by animals. That was the first animal law class. No casebook, just us. We were terrified that activists would find out about us because we had no ability to operate as a law firm. We all had full-time jobs. We didn't have an office. We didn't have equipment. We had none. But we taught ourselves about a wide variety of animal-related issues. Meanwhile, and I'm skipping around here, and you'll see why, hopefully, in a few minutes. Meanwhile, in Detroit, Michigan, there was a learned law professor named David Faber. And he was starting to think about animal rights, although he was an environmental specialist. And in 1979, he published an article called Wildlife Rights, the Ever-Widening Circle. And this article marked an important intellectual and emotional transition for David Faber. He had shifted from the traditional environmental law perspective of viewing animals as a group or as a species. Now he began to think of them as individuals. At the same time, and it's interesting that this was all happening at the same time, although if you think about it, 1975 was what? Anybody? Publication of Animal Liberation by Peter Singer, right. That was a big part of this. New York City, there was a small group of attorneys who were meeting. They were actively representing tenants with companion animal issues and other animal-related law issues. And this group was led by Jolene Marion, who coincidentally, Jolene and I knew each other from college, where we ran a quasi-legal campus cats group. And spent a lot of our time when we weren't in class placing cats and getting them medical care. You see that thread is always there. And at the same time, there was a scrappy young lawyer in Boston, Massachusetts named Stephen Wise. And he had read Animal Liberation around about that time, and he thought that Peter Singer made a compelling argument. So he took his first animal law case in 1980, which was a vet malpractice case. And he liked it. He kept taking those cases. And since he was the only one in the area who was doing that, radio talk show hosts started inviting him on, and he was talking about the potential for creating legal rights for animals. And at that point, he thought he was the only lawyer working for animal rights. I like to joke that he still thinks he's the only lawyer working for animal rights. In March of 1981, we got a call, and we, being Larry and I, got a call from someone who said that the US Navy wanted to kill 5,000 feral burros in the Mojave Desert. I wasn't quite sure what a burro was. I kind of figured they were donkeys, and yes, they are. The Navy had and has a naval weapons testing center in the Mojave Desert in China Lake, California. And the problem that they were facing is that at night, when it gets very cold, burros, being sensible animals, would come up on the airstrip where they would get water and warmth. The problem, a burro could down an airplane. And so the Navy's response, rather than building a fence around the airstrip, was let's kill 5,000 burros over a period of weekends by having sharpshooters come out, and that will solve the problem. I understood the problem. I just didn't agree with the answer. So pulled an all-nighter, went into court the next day using the National Environmental Policy Act, NEPA, and was able to convince a judge to give us a temporary restraining order, which I didn't realize at the time. I was 3 years out of law school. I didn't realize at the time that that's a difficult thing to do. But after we got the TRO and pissed off the Navy, Marcel Philpott-Bryant, an attorney in Los Angeles, joined me, and we spent the next 8 months negotiating, cajoling, getting to know the Naval Weapons Center's attorneys, visiting the Naval Weapons Center, sorry. And at the end of the 8 months, we were able to settle the case, and no more burros were killed. So there were some rather interesting things about this lawsuit for me. First, we were using NEPA in a way that environmentalists would not support, frankly, because those burros were actually eating endangered plants. Secondly, these were animals who were not endangered or threatened, and they were not even native to the area. So here we were using this law in an unusual way. Second is that when I chose to drop everything, pull an all-nighter, and get that TRO, it marked a turning point in my life. I didn't realize it at the time because I was too busy thinking about burros, but Common sense would have dictated that I not take that case. I was an associate in a firm. I wasn't doing all that well as an associate. They could tell I was unhappy. This just was sort of the final nail in my casket. I didn't know federal law. I didn't know federal procedure. I had less than 24 hours to get into court. All of that dictated against, and I didn't think about any of that. The third thing was that a few months after we got the TRO, one of our clients, the Animal Protection Institute, came to me and asked me a very special question. And the question was, what can we do for you? I love that question. And I told them about this dream that I had to leave private practice and start doing this work full time. And they agreed, amazingly. And they gave us a grant of $6,000. Hey, it was enough. I lived on $1,000 a month for 6 months, and a lot longer than that, and started to do this work full time. I was the executive director of ALDF. I was the litigator, the only litigator. Well, no, the chief litigator in-house. The fundraiser, the director of facilities, communications. My idea of success has been each time I've been able to pass off one of those jobs. And I've been able now to pass them all off, including the executive director. Our first annual budget was $12,000, but we made it work. Now, my point in telling you all of this and jumping around the country is that the roots of the animal law movement were happening in various parts of the US, but we didn't know each other. And we needed to be brought together. Remember, this was 1979 to 81. No internet, no cell phones, computers, no. Selectric 2 typewriters were the state of the art at that time. And what we needed was some nexus, and that was Holzer. Holzer was the visionary. He was the one who could see that the whole could be greater than the sum of the parts. And on Thanksgiving weekend in 1981, he brought us all together to New York City and held the first ever animal rights law conference. And he told Larry and me that we needed to occupy the field, which I thought was hilarious. What field are you talking about? There's just a few of us. We can't even form a basketball team. But OK, yes, sure. And that's where we met Stephen Wise and David Faber and Bill Reppy, who was teaching at Duke at that time, and Eleanor Mulbegot, who was working for the SPCA, and Peter Lovenheim, who was a staff attorney for HSUS at that time. About 60 people, half of them lawyers, showed up at this conference in New York. And it was just an amazing experience to walk into the room and for the first time to see like-minded people for the first time in my life. It was extraordinary. And we formed a national board of directors. And does anybody see anybody in this room who's now sinking into her chair who is on that national board of directors? Yeah, yeah. Our longest-standing director, Sarah Lewick. So this is the pointer. So you've got, there's Sarah, hasn't aged a day. Marcel Philbott-Bryant, me. Roger Galvin, the prosecutor who prosecuted the Taub case. Jolene Marion. David Faber. Nancy Shestak. Steve Wise. Standing next to Gary Francione. You will not see that again. Ken Ross from Illinois. Larry Silver, who basically was my mentor when I left the firm and needed help from an experienced attorney about how to handle these cases. Peter Lovenheim, who was with HSUS and then joined our board, and Nancy Ober from San Francisco, who was on our board for many years. It was a small group, and it was a very tight group. We supported each other emotionally, intellectually. We talked about the kinds of lawsuits that we could bring and the issues that we wanted to address. It was an activist working board. It was not a board that sat around fundraising, mainly because nobody on that board knew how to fundraise, neither did I. We combed through state laws and federal laws, and we looked for hooks to develop causes of action. And we agonized. We agonized over the most effective courses of action. And we wrote white papers, and we analyzed opportunities and challenges. And we talked about how to grow the organization and the movement. And we were very young, and we were pretty naive, frankly. We had very little money. We were spread all over the country. We would communicate mainly by phone, but we'd get together about 4 times a year on weekends. We'd all fly into either DC, where Roger lived, or Boston, where Steve lived at that time, and we would bring our sleeping bags, and we'd sack out in the living room, and then we'd meet for the whole weekend. And we began to work on a broad spectrum of issues and all possible species: hunting, trapping, research labs, companion animals, not so much farmed animals. And with each case, we were trying to get courts to do something that they had not been asked to do before. We were trying to get them to treat animals as beings whose lives and interests matter. That was very new and very different, and it was literally trial and error with each case. In most cases, this was the first time that judges were hearing such arguments. In many of these cases, we were laughed at. Judges didn't think we were serious, or they thought we were crazy, whichever. There are a lot of those cases, and we now currently have about 50 on our docket and another 90 that we're researching. But I'll give you 2 of the early ones so that you get a sense of what we were working on. Sarah, get ready. ALDF versus Praveen Field. This case was actually the brainchild and the work of the Boston chapter, which included Sarah and Steve and other people. And it taught us that you cannot ask a group of volunteers to handle a whole litigation, a whole lawsuit. It doesn't work well. But calves. Anybody spent time with calves? Anybody in here? Yeah, a few of us. OK. They're like puppies or kittens. They're playful. They're exuberant. They're a lot of fun to be around. They're very cute. The problem, and I think if anybody's taken the animal law class or knows anything about animal law, you probably already know. The problem is that the dairy industry considers the male calves to be garbage. They don't produce milk. They have no use. So the Praveen Corporation created a use. Take the calves away from their mothers, put them into these stalls so they can't move around and their muscles can't form well or grow. Give them a diet that lacks iron so that they become anemic. And the consumers prefer a white meat to a red meat. And so the body parts become more white. This is called milk-fed or special-fed veal. Great for the farmer, because they now have a use for the male calves. Great for Praveen, but it's a life of misery for these calves. Without iron, they get very sick. Stuck in these crates, they're very unhappy. They've been taken away from their mother. So how do you challenge this kind of abuse? And what the Boston chapter did was a great deal of research to realize no federal law in any way sets standards for how animals are raised on farms. No state law was setting minimum standards. In many states, farmed animals are exempt from coverage. And even if they are protected, the cruelty laws can only be enforced by prosecutors, not by civil litigators. So what they came up with was this idea. Go for injunctive relief to bar Praveen from selling the meat of these veal calves because the total confinement of the calves violates the state anti-cruelty laws, and the meat is tainted and unhealthy. It lacks iron. And second, they sought injunctive relief to require any seller of this veal, this special or milk-fed veal, to display on the package a truthful explanation of how the calves are raised so that the consumer can make an informed choice. Okay? It was an innovative idea, and of course, we lost. The court held that there is a federal scheme regarding meat packaging which preempts state law, and the judge said, you're just trying to do an end run around the cruelty laws. Now, one of the lessons that we've learned along the way is that trial judges see their role as maintaining the status quo, and we were asking judges to do the opposite. Our legal system is built on precedent, and if we're going to change the way the law views and treats animals, number one, it takes time. But we also have to find a way to speak to judges in a language that they understand. And at the trial level, don't let them know that we're asking them to make these radical changes. Make it seem simple and not all that different. Another case, which was really innovative and ended up, and I'm sorry, I should have told you graphic. Another case that was done in the mid-'80s was this one. It was Longtime versus Iroquois Brands. And for those of you in the animal law class, you're going to read this one. This was the first, although indirect, challenge to the production of foie gras. Peter Levenheim, who you saw a picture of, worked for the Humane Society of the U.S., was on our board, and on the side, he liked to invest in stocks. And he'd found a company called Iroquois Brands, which distributed health foods. And he thought, OK, this is a safe stock. But later, when he got their annual report, he learned that they also distributed French foie gras. Now, he was aware of how the duck and goose liver pâté is made. It's highly controversial. It's done by painfully force-feeding the birds so that their livers enlarge to 8 times what they would normally be. Okay? Peter remembered when he was sitting in his corporations class in law school, and he read a case called Medical Committee for Human Rights versus SEC. And in that case, the shareholders brought a resolution to Dow Chemical asking the company to stop selling napalm unless they received reasonable assurance that the napalm would not be used against humans. Point of reference, it was used against humans in the Vietnam War, and probably in a lot of other instances as well. In that case, the Court of Appeals had upheld the plaintiff's right to bring a shareholder resolution on an important moral issue. And Peter thought, well, let's try this with animals. So I will make a long story short. He started with a letter to the president of Iroquois Brands. He received a polite response. Polite response, go away. Then he decided to bring the shareholder proposal. And he did that for 2 years in a row. He brought a shareholder proposal. And in that shareholder proposal, he spelled out in great detail what the process is and how painful it is and how it is a moral issue. After 2 years of bringing the shareholder proposal and Iroquois refusing to put it on, he decided to sue, which he did. He sued under SEC Rule 14A8. And then he went to court. He actually brought in an attorney who specialized in SEC, which was lovely. They went to court. And lo and behold, they won. The court agreed that Iroquois Brand must address the ethical and social issues relating to cruelty to animals. And today, that might not seem like such a big deal, but in 1985, that was a pretty big victory. And the New York Times, Washington Post, Associated Press all covered it, all going into detail about the way in which the ducks and geese are fed or force-fed. So what could have been treated as a fringe issue was viewed seriously in the context of a shareholder proposal. Now, Peter realized at this time that he had created a vehicle that could be used on a broader basis. So he brought the idea to one of the leading activists, Henry Spira, who used it in his campaigns. And Peter also brought it to PETA, which still actively uses shareholder proposals with pharmaceutical and cosmetic companies. So each of these ideas, some went no place, some went pretty far. The reason I'm here this weekend is for the AWA at 50 conference, something I think that probably is not much of a cause for celebration, but I am very interested to hear what my colleagues have to say about the AWA. For me, one of the most frustrating aspects of the work we have done was a series of lawsuits that we brought over that length of time in a failed effort to breathe life into the protections of the Federal Animal Welfare Act. The AWA was passed initially in 1966. Our group was really starting to get off the ground in the mid-1980s, and we started these lawsuits. Suffice to say, after all of this effort, hundreds of thousands of dollars in attorney time, and a lot of blood and sweat, we could not even gain minimum standards for mice or rats. We couldn't get primates out of isolation. We couldn't get exercise for dogs. And I have felt a terrible sense of failure and a powerlessness to help these animals. But more recent events have caused me to realize that perhaps my focus was too short-term, that maybe all that was done in the 70s and 80s and 90s, the protests, the demonstrations, our lawsuits, the AVs, all of those efforts were sowing seeds for the future. Because over the past few years, there have been some fascinating developments In 2008, the National Research Council, National Academy of Sciences, published a report in which it said that the use of animals in toxicity testing is a broken system. We need to develop alternatives that are faster, cheaper, and more closely predict the possible dangers to humans. And that is an enormous sea change. I mean, that is a very exciting development. This was scientists saying the system is broken. We cannot continue to use animals and bring chemicals out that have been tested properly. And so we have been sitting, along with Paul Locke and others, in the same room with toxicologists and pharmaceutical companies and the EPA, and dialoguing about how can we create change that will be better for human beings and will also spare the lives of millions of animals. And I've talked to young scientists at conferences who are being trained solely on in vitro, non-animal techniques, which is very, very exciting. Paul and I were talking last night, and he says it's about 100 years until we'll get animals out of research. Obviously, none of us will be there. Peggy says sooner. Sooner. Peggy Kniff says sooner. But it is exciting to see at least this kind of change. And another major step forward. Oh, sorry. Paul, I grabbed that from you, I think. So. Another major step forward, and believe me, I never thought that I would ever quote Francis Collins, but the National Institutes of Health has released a series of announcements, culminating in an announcement that it will no longer fund research on chimpanzees. All remaining NIH chimpanzees are going to sanctuaries. When I saw this series of announcements, my teeth continued to fall out. NIH, the defender of animal research, publicly saying that, nah, we're going to not fund research on chimpanzees. That's exciting. Hallelujah. Jumping back to the 1990s, the field was starting to expand. Sorry, there we go. And we were getting in lawyers from more diverse backgrounds and with different approaches. For example, Kathy Meyer and Eric Glitzenstein started at the Public Citizen Litigation Group, Ralph Nader's litigation arm, where they learned about consumer protection, federal admin law, statutory interpretation, FOIA. And in the late 1980s, they decided to take those skills and apply them to the protection of wildlife. They formed their own firm, and there was a huge backlog of species that were not being added to the endangered or threatened species lists pursuant to the mandate of the Endangered Species Act. I believe there were 400 in all. So Meyer and Glitzenstein, representing the Fund for Animals and Defenders of Wildlife, filed suit against the Department of Interior. And after many months, they were able to negotiate a settlement in which 400 species were listed. And this was the first in a long line of cases that Meyer and Glitzenstein, and now Meyer, Glitzenstein, and Crystal, have brought to protect wildlife and other animals. They're one of the few firms, they do both environmental and animal law, and they're one of the few firms that has made a successful career of doing this work in private practice. Another thing that started happening about that time, and I realize that some people are going to need to leave at some point, was that we began a criminal law focus. This was not my idea. This was other people saying, you know, maybe we can make headway through criminal law. Now, as civil litigators, once again, we cannot enforce cruelty law. But what we can do, and what we have been doing, is we contact prosecutors handling cruelty cases, and we offer them free legal assistance. Whatever you want us to do, we'll do it. If you want us to do research, if you want us to write an amicus brief, if you need expert witnesses, tell us. We'll find them. We will pay to get them there. We'll pay for DNA analysis. We'll pay for the development of forensic evidence. And at first, prosecutors were wary. But as they started to use our service and they realized there were no strings attached and that we did want to help them win the cases, they started coming back. We now work very closely with prosecutors all over the United States. We also partner with the National District Attorneys Association and the Association of Prosecuting Attorneys, the two national groups of prosecuting attorneys. And we've seen some really interesting decisions come out of this. For example, oh, too far. OK, sorry. A couple of Oregon cases, State versus Nix and State versus Hess. In each of those cases, the defendant had been convicted of multiple counts of cruelty. Nix involved dogs, Hess involved cats, multiple, large numbers of animals. They were all being severely neglected, hoarding situation, things like that. But when it came to, when the defendant was convicted, even though multiple animals were involved, the defendant would argue that they were not separate victims, that it was all one crime, and it should be sentenced as such. And we wrote an amicus curiae brief and have been able to help prosecutors establish the law in Oregon that when you've got multiple animal victims, each animal counts, which, again, seems like a small point, but each step we take when a court recognizes, when the legal system recognizes that animals have interests, the interests matter, that gets us a step closer. Here's another one. This was just a month ago. There was a Pennsylvania cruelty prosecution in which the defendant, who owned this dog as a puppy, 6-month-old Luke, threw Luke against the wall so hard that he shattered Luke's shoulder. The man's girlfriend later called the Humane Society and told them what had happened. And so the man was charged with cruelty to the dog. At trial, the girlfriend refused to testify, and therefore there was no eyewitness, and the boyfriend, the owner of Luke, was acquitted. At that point, he demanded to get his dog back, and the prosecutor called us for help because she couldn't imagine that dog going back to this man who had done something so horrible to him. And our criminal justice staff, I'm really proud of them, they developed a new argument, which is, okay, the boyfriend could not be convicted at this point for the cruelty of throwing the dog against the wall, but he had also failed to take the dog to a veterinarian, which was a separate crime of neglect. And that could be considered, as I said, neglect. And since Luke, the dog, was the subject of that crime, he could be considered derivative contraband. Under Pennsylvania law, the court could order the dog's owner to forfeit the dog. The court agreed with the derivative contraband argument. It can now be used to protect other animals in this kind of situation where the person's acquitted. And Luke, the best part of this is Luke is now in a loving home. And he's not going to be abused like that again. So in the early days, most of us self-identified as animal rights lawyers. I love that picture. If you look there, yeah, okay. Today, that's a rarity. I don't hear people self-identifying as animal rights lawyers as much. And one of the internal tensions in our movement comes down to a simple question. Should we work for the rights of animals, or should we work for protection, welfare? Which will get us further? Where should we put our energies? Steve Wise has committed himself solely to working for rights. David Faber has written extensively about it. If anybody's interested, I've listed some of their works. Steve has said, working for protection is merely nibbling at the edges. John Lovern, on the other hand, the head of Humane Society of the United States litigation team, vehemently argues against what Steve Wise is doing. He says billions of animals are suffering enormously right now, and positive reforms are attainable by taking a more pragmatic approach. So I'll ask you this question when we're done. Who do you agree with? Is it possible to do both? Or do we have to commit to one or the other? And which way are you going to go? Now, how am I doing? Oh, I'm getting close. OK. I'll end with this. Farmed animals. We really didn't start working on farmed animals until around 2000 in the movement for a variety of reasons. But that's surprisingly recent, especially given that they are by far the largest number of animals who are killed every year, and they face the most intense long-term suffering. CAFOs. Confined or concentrated animal feeding operations, often known as factory farms, although I don't think the word farm should be used. They have nothing to do with farms. They constitute one of the major health, animal protection, environmental challenges of our generation. And yet, most people don't even know they exist. They still think it's old McDonald's farm going on. There is no federal law that protects animals while they're in the CAFO. None. There's the humane transport, there's the slaughter law, but nothing for the 99% of the time that these animals are in factory farms. State laws. The majority, 75% of state laws specifically exempt farmed animals from their protections. So what we have is no law for the most part. That changed somewhat, and the game changer was HSUS starting around 2000 and putting substantial amounts of money into state voter initiatives, starting with Florida and then moving on to other states. That woke up the farmed animal industry, the meat industry. Finally, we were able to get a toehold and create some change. There are only a few states, however, that have these kinds of laws. So what do we do for the rest of them? And of course, we know that the animals who are in these places are owned by the very people who are causing them the harm. So standing is an issue. Getting into these places is an issue. So we've had to come up with unusual roundabout legal theories that allow us to get into court. One approach is the use of consumer protection laws. And that's what this shows you. This is Judy's eggs. And as you can see, there's hens in the field, and I come from Sonoma County, by the way. That is how we dress our children. And the packages say these hens are raised in wide open spaces in Sonoma Valley where they are free to roam and scratch and play. Well, that's where they are. Anybody see the chickens? Yeah? You see a chicken anywhere? Yeah. No. That's what it really looks like. The chickens are all inside. They're in massive facilities, and they're intensively confined. There's no fresh air, no sunlight, no grass, no bugs to chase unless those bugs happen to get into that building, no room to roam, no ability to be a chicken or to have, follow any of their natural instincts. Americans are willing to spend more for higher levels of animal welfare, for what we call free-range eggs, because they find the suffering of these chickens to be objectionable. And so Judy's packaging was deceptive, implying that the hens are free-range when they're not, provides an unfair advantage over actual free-range producers, and it misleads well-intentioned consumers. We filed a class action lawsuit on behalf of all consumers who had bought and paid a higher price for these eggs, and we won. Well, we settled, actually. We alleged that, you can see what our allegations were, deceptive advertising and marketing in violation of California's unfair competition law, false advertising law, consumer legal remedies law. And we settled. They stopped advertising. They took the hens off the package. They probably kept the kids on there. They took out the language about them being impliedly free range. They agreed to pay some hefty settlement amounts, including attorney's fees. And they agreed to make some structural changes to their barns so that the hens will have more room. They did not agree to let them outdoors, which is unfortunate. But it made a point. It made them very miserable. We can go after other producers in the same way. So with that, I want to stop. That gives you some idea of what we had been doing in the past. You can check our website. And I'm going to go forward. The animal law programs, yay. And for the remainder of the time, you'll see pictures of healthy, lovely animals, the way, my dog, they're supposed to be. Yeah, that's my next career, pig masseuse. So with that, we have a long way to go. We've been doing this for 44 years. It's very young for a movement. I hope some of you will join us in this fight, and I'm open to questions if anybody has any. Thank you for listening.
Thanks, Joyce. If anyone has any questions, raise your hand, and I will come bring you the microphone so you can be on the recording.
Hi, Alan Goldberg, Johns Hopkins University.
Hello, Alan.
Judy, thank you for the presentation. I think I would ask you the question. The case of the chimpanzees and how that went forward really is a roadmap to the animal rights and welfare and protection community for how to make progress within the field. And it is not an approach that requires confrontation, but it really requires cooperation and scientific data. The reason the chimpanzees were eliminated as research subjects were the data demonstrated that they did not provide useful information. I suspect studies looking at the use of rats and dogs and chickens and mice under the same circumstances will have, in some cases, similar, but in other cases, different results. And it's a way to begin working with the scientific community to really get rid of animals.
I think that'd be a wonderful approach, and yes. You know, we were very confrontational back then. We didn't get anywhere. Now, we may have gotten somewhere because all of the pressure added up, but you know, it's very hard. The scientific community for us as lawyers is a giant, is a high wall that we can't seem to get past. In Europe, animal protectionists and scientists do meet and do have conversations. I would like to see the same thing happen in the United States.
Any other questions? I'll just add one thing. In the Judy's Eggs case, one thing I appreciated, you often hear from the outside people pointing fingers at the animal protection community, telling that they're in this for their own ends. But with the $50,000 settlement that was arranged there, ALDF donated that to a local rescue that had rescued a bunch of hens from another egg facility that was damaged in a storm, and the animals had just been abandoned. So,
yeah.
Any other questions?
Yeah.
My name is Concha Gandhi, originally from India. I just want to share my experience. I lived in a big urban city where it was a very small apartment, an old-fashioned apartment. And the whole house was infested with mice and cockroaches. But none in my family want to kill any of it, because killing is against our philosophy. So we just let them roam. And even from a distance, we appreciated how the mouse was eating my mother's cooking from a distance. So, of course, there was, I don't believe there was any kind of infection or disease from these minor creatures. But when I come to this country, you know, big care and big attention is given only something what we see usually, what we call pet animals and wild animals, but not at the very minor level. So this is my observation.
I think that's actually an issue here at Harvard Law School, and I think the ALDF might be working on something related to just that. More to come, I think.
Hi, I'm a 2L student here. I come to a lot of animal law, environmental law events, and one thing I notice is that I'm always one of very few people of color in the room. I think today we're actually doing relatively better, and we're really not doing very well today either. And I think one thing we're learning now is that it's really communities of color that are most impacted, because we live near the factory farms, we work in the slaughterhouses, and we are the ones on the front lines having such negative health outcomes. So I wonder if there is any dialogue within the animal law community or any efforts to spread that information and get more communities of color involved.
Thank you for raising that. Yes, actually, at our last conference, we had a panel on racism and sexism in the animal rights movement and in the animal law movement, and it was very well attended. It turned out to be one of the two favorite panels when we did the surveys, and people want to talk about this. And I think we need to break out. We, white people, need to break out of the way we've been thinking, and the way we've been thinking is, why don't they come to us? And we don't realize what we're doing that causes that. And it's complex in a lot of ways. Let's set aside sexism for a moment, because that's also rather rampant in the animal rights, animal protection movements. But with regard to racism, we need to approach people differently. We need to speak differently. We need to be very careful when we make statements about slavery in the U.S. that we're not offending people. Same with the Holocaust. There's a lot that we could be doing. That was so popular that we're going to have a panel on it again at our next animal law conference. And it is something that we want to see talked about with the majority of people in the movement more, because there's so much that we can be doing. You mentioned that people of color tend to live in the communities where CAFOs are. Yeah, And they're the ones who are being hurt. They're the ones who are smelling the bad air. They're the ones whose water is being impacted. And so one of the things that excites me about the CAFO issue is that it enables us as a movement to build a larger tent and to be working with food policy people and environmental justice folks and environmental people. We can all be working together on these issues. And hopefully, as we do that, we will each get sensitized to the other's issues a bit more.
I would just add there's a really good article written by Angela Harris called Should People of Color Care About Animal Rights? We're trying to get her here for our Animal Law Week in the spring as well.
Yeah.
I feel like a game show host.
Huh?
I feel like a game show host.
Thank you very much for coming. My question is, to what extent do you notice a shift in the fruitfulness of animal law or animal welfare and animal rights legal endeavors based on who the party in power is in the country? Is there any difference in like the USDA's practices?
I don't think so.
There's none.
We'll see. I mean, USDA has been so terrible for so long. I suppose it could get worse, but I don't think it much matters. And you say the person in power, the person who's coming into the White House, is that who you're referring to? Yeah, no. We've never had anybody particularly good in the White House on animal issues. We are starting. I see progress. It's hard when you're in the midst of it to see the progress. But one thing is, when we started focusing on getting animal law classes into law schools, the idea was that we don't get laughed at as much by judges, because law schools obviously where judges and politicians and lobbyists and legislators and prosecutors and all these other lawyers come from. What's happened has actually gone beyond that. We today have 1,700 attorneys who are doing pro bono work for Animal Legal Defense Fund. HSUS has an equivalent number. We're working with 450 law firms. Last year, we estimate that we got over $3 million worth of pro bono legal representation, which allows us to, as you can imagine, expand the work that our staff attorneys are doing by a lot. And that's coming from, I think, the animal law classes, as well as the state bar, the American Bar Association Animal Law Committee with TIPS, which Chris is a part of. All of these are mainstreaming animal law, and as that happens, we're going to see more and more progress. But I've seen progress in other ways as well. Do we need to?
And I'll just lastly add, I do think with the USDA, Bernadette Juarez is now the head of animal care, so she's in charge of enforcing the Animal Welfare Act, and she is, I think, even though she's operating with a very confined structure, she's a quantum leap over her predecessor. She Skyped into our animal law class last spring and really won a lot of the students over, and she has agreed to come speak at our conference here this weekend, which I think is a very large step to come into this environment and face those questions.
I look forward to meeting her.
I think that's about it. Does anyone have one last question? I think we've got time for one more. Oh, Sarah Lubick. Perfect.
Sarah has a comment.
Yes, Sarah.
I just want everyone in this room to know that there are heroes that you meet in life, and there's mine, and a lot of other people, and there would be, in my view, no current, amazingly, explodingly successful animal law in the United States without that lady right there.
Thanks, Sarah.